Good afternoon. I'm Max Brantley with the Arkansas Times on Monday, August 29th. The lead news story in Arkansas today, I'd say, is the Arkansas Bar Association's announcement that it's filed a suit to challenge Issue 4 of the constitutional amendment proposed for the November election ballot. It would place a severe limit on damages in lawsuits against nursing home, hospitals, doctors, and other health-related effects. The Bar Association is somewhat different from the Trial Lawyers Association. It represents attorneys on both sides of the bar. I think that's significant. The lawsuit says that the amendment would essentially end the right to a trial by jury in Arkansas by setting an arbitrary limit on damages and an arbitrary limit on attorney's fees. It would effectively stop lawsuits for non-economic damages, particularly for young people, for many women, for older people who can't prove economic damages, have only suffered terribly because of nursing home abuse and neglect. They couldn't sue. There wouldn't be enough money in it to file a lawsuit. There's a question of whether punitive damages would remain. There are a variety of arguments raised about the sufficiency of the ballot title, particularly in not revealing to voters how much power this shifts from the Arkansas Supreme Court to the Arkansas legislature. Not a happy thing, in my view, given our legislature today. Elsewhere, really troubling news from Reuters that the evidence has been found of efforts by foreign hackers to get into election databases in 2 states, perhaps Arizona and Illinois. This is cause for a warning from the FBI to all be careful about security of voter data. In Arkansas, we have to wonder about the security of our voter data for other reasons, and that's the incompetence of the Secretary of State, Mark Martin. He sent out a list of more than 7,000 people to county clerks, suggesting they should be removed from the rolls. He knew the list was bad. We now know from Larry Crane's hard work in Pulaski County that fully 2/3 of the list was in error. Mark Martin was ready to throw 1,500 people off the ballot in Pulaski County simply for he got a data list and said, do your job. Larry Crane did his job. Other clerks have not been so careful about it, unfortunately. Mark Martin's also working with another vote suppressor, Kansas's Chris Kobach, on a state cross-check list that's badly flawed, that also throws people off the ballot with a particular bias against minorities from a poorly assembled group of similar names on the vote. So we may have to worry about Russian hackers nationally. We need to worry about Mark Martin in the state of Arkansas. Mayors Mark Stoll of Little Rock and Joe Smith of North Little Rock and County Judge Barry Hyde have, to nobody's surprise, thrown in with the road building lobby in the State Highway Department in endorsing the Highway Department's idea of widening Interstate 30 through Little Rock and North Little Rock to 10 lanes. It's a bad idea for the neighborhood. It'll further deteriorate the cities that freeways everywhere have done. But in Arkansas, we think in conventional terms, not in terms like great cities like Vancouver have done and rejected freeways precisely because of the damage they do. But there's still hope that a lawsuit perhaps will slow down the progress of that project. Gilbert Baker, a former state senator, a former Republican state chairman, a former candidate for U.S. Senate for the Republican Party, was arrested for DWI Saturday in Conway. It's an unfortunate thing for him. He apparently had a problem that caused his arrest. It's interesting because he's been a supporter of laws that prevent liquor permits in dry counties, and he's worked in behalf of liquor stores in some monopoly counties to keep other counties, such as his home of Faulkner, from having alcohol sales. He's often taken the family values view that alcohol is a damaging thing. Indeed, that's true. A group that supports the rights of LGBT people on college campuses has distributed a shame list of 102 colleges that it says are unfriendly to LGBT students because they've sought waivers from the federal government that allow them not to comply with the Title IX civil rights law. They want, on account of religion, to be able to discriminate against LGBT people and also against women in some cases, single mothers, women who've had abortion, that sort of thing. There are 2 colleges on the list in Arkansas, Harding University and Williams Baptist. Both have sought the exemptions because of their beliefs, their religious beliefs. The sadder thing, I think, on the list by Campus Pride is that of their database of schools that are friendly to LGBT students, not a single one from Arkansas appears. We need to work on that. Interesting editorial comment. There was a strong op-ed in the Arkansas Democrat Gazette today by Susan Streett, the president of the Clinton Foundation, about the value of the Clinton Foundation, certainly in Little Rock and in worldwide programs as well. She observed that the hometown newspaper for the Clinton Library, where the programs here are pretty demonstrable, said that it seemed okay to them to close the foundation down. Pretty amazing point of view from the hometown newspaper of a pretty vibrant and important element of our city's infrastructure. City residency is again an issue at City Hall. Little Rock Board of Directors are going to consider a proposal to require city residency for police officers. That's not likely to be approved, More likely to get some favorable attention is the city manager's idea to give some grants to people, future employees of the city, up to $5,000 for people who buy homes or lease apartments in the city of Little Rock. Getting more people who work for the city to live in the city could not be a bad thing. Hope that works out. And finally, today's hypocrisy report. Attorney General Leslie Rutledge last week asked the U.S. Supreme Court to overturn a state ruling that said state law allows wide open access under the Freedom of Information Act to driver accident reports. She says a federal law should prohibit this. Leslie Rutledge, you may remember, styles herself as a federalist, a states' writer, if you will. That is, the states best know how to run their business. And here she's going to one of those evil federal courts to enforce a federal law over a state law which, by the way, is far better in the public interest than the federal law. Explain that to me if you can. I'm Max Brantley. I'll be back tomorrow.